People come to me all the time. Should I give the house to my kids while I'm still alive? I say, do not do that. Please do not do that.
Yeah. Then your house is now subject to their creditors also.
Right. Most people might come in with the attitude of, this is very simple. One of us goes, it goes to the other. Second one goes, everything goes to our kids in equal shares. But when we start to dive in a little bit more,
the Kennedys, the DuPonts, the Rockefellers use this type of planning. And the reason they have the wealth is because
each financial decision is not in a silo by itself. It has to be looked at how it relates to something else in your plan. And most people are not looking at the big picture.
This is John Smallwood, and I am back on Money Isn't, and we have a amazing guest with us today, Michael Canarick, JD LLM. Welcome.
Thank you very much, John.
Good to see you. Now, you have your master's in taxation from NYU.
I do.
And you are New York, New Jersey, and Pennsylvania bar.
Correct.
You are the founder of the Canarick and Canarick law firm and managing partner based in Red Bank, New Jersey.
That's all correct.
And tell me a little bit about your personal self, like what you do for fun and what your, kids, the whole thing.
Yeah, I have two boys. One is turning 18 tomorrow and leaving for college tomorrow. So that's
tomorrow.
That's my big news.
And where's he going again? I think you told me.
College of Charleston.
Oh, beautiful, beautiful city.
Everyone's very excited. I also have a stepdaughter who is going to be a junior in high school, and then my younger son who's going to be a sophomore in high school.
Wow.
So
You're right in the thick of it.
Yeah.
First kid going to college.
So
it's an amazing experience sending I have 4 that I sent, and each one you have an additional, you have a different emotion that comes up, right? It's completely different because of who that child is and where they're going. And it's probably the greatest growth. Like that kid will come home in, maybe December, maybe for Thanksgiving.
Right.
And be a completely different human being.
Yeah.
Hopefully in a positive way.
Yeah, I think so. Yeah.
Right?
I definitely went through that when I went to college. I had a great experience and definitely.
Have you been to Charleston often?
I've been there 3 times prior to this, and obviously I'll be going more frequently now. But I think it's one of the top handful of cities in the country.
Yeah. Favorite restaurant is Hall's Chop House.
I
don't know if you've been there.
I haven't been there, but I know exactly where it is.
High Cotton.
Okay.
And Snob, slightly north of Broad. Those are they're the 2 of them are tourist traps, but Hall's is like the most unique experience from a steakhouse that I've been in a long time.
Yeah, I'll have to check that out. We have reservations tomorrow night at Fig.
I've heard that. Yeah.
Which stands for food is good.
Yeah.
I had gone there in the past, and then when I took my son to visit the school, I took him there, and he loved it. And so when we were going for the drop off and his 18th birthday, he said that that's where I want to go. So
that's awesome.
We're going there tomorrow night.
My middle son Jared went to Fordham, and Arthur Avenue was right out the side door, and it became food fest. Like, who had the best chicken parm? Who had the best this? And we would go, literally, my wife and I, kids, we would just go periodically just to experience the Arthur Avenue experience. It was amazing.
Yeah.
But we're not here to talk about that, right?
Yeah.
So what it's the big, beautiful bill in estate planning has a whole bunch of new nuances and things that we should be really considering. And I wanted to bring you on the podcast today to talk more about complex estate planning than the basics. But I always want to begin with, people are like, they come in to our wealth management ecosystem and it's like, they want to be super complex, but they haven't done the basics.
Yeah.
And to me, we've got to start with a foundation and then get complex.
Right. Yeah.
So,
I think a lot of times people equate estate planning with estate tax planning, but there really is a whole lot more to general estate planning. Especially in today's day and age, there's, I guess, I don't know what the right word is, more non-traditional families, more, merged families, kids from different marriages. You have couples who don't have children. You have couples who have children, but they're not married to each other. These all present a whole host of issues.
It's a lot more complex than it's been.
And that has nothing to do with tax. In addition to that, there's, even traditional families, there's discussions to be had about how you would want to pass assets to your children. Most people might come in with the attitude of, this is very simple. One of us goes, it goes to the other. Second one goes, everything goes to our kids in equal shares. But when we start to dive in a little bit more, and I say, yeah, are you sure you want to give the assets to the kids? Should we talk about giving assets to trust for the benefit of the kids for a whole host of reasons?
Asset protection.
Asset protection. If a child gets divorced or sued or has creditor problems, don't you want that money to be protected? If the child, or when the child ultimately passes in the future, do you want that money going to their spouse, or do you want that money going to your grandkids?
Smallwood Wealth Management is the lead sponsor of this podcast. You have an opportunity to have a free, no obligation conversation with one of our qualified advisors. Go to smallwoodwealth.com, schedule a call, or call us at 800-797-1000 and get on our calendars.
There's a lot of non-tax stuff in estate planning as well. But obviously, the big, beautiful bill passing has a lot to do with the tax side of things.
And I think it's interesting because there's this perception that if I don't have an estate tax problem, I don't really need to do documents. And my father used to talk about, like, what would be the worst nightmare for your estate plan? And people are like, I don't know. He goes, what if your ex-son-in-law's family ended up with all that money that took you 50 years plus to create?
Right.
And they're like, what are you talking about? He goes, he just would explain that divorce and that concept. And like, people get freaked out by that.
Yeah.
And then it's like, I see so many mistakes I think one of the cleanest things in the current estate tax law is a step up in basis.
Yeah.
Right. Which means, to put this in English, I own 100 shares of XYZ. I bought it at $1. If I sell it and it's worth $100, I'm paying tax on $99. When I die, the $100 right now becomes market value. But if I gift it to my kid or to some kind of entity, the basis follows.
Correct.
And now they got to pay the tax. I see people making the mistake with, got to get the house out of my name.
Right.
I got to get this.
Yeah. People come to me all the time. Should I give the house to my kids, while I'm still alive? I say, do not do that. Please do not do that.
Yeah. Don't. And then your house is now subject to their creditors also.
Right.
Right. So tell me, you've been doing this for over 20 years.
Yeah.
It's close to 25
years.
Yeah. Right. So your practice has really evolved from, basic wills and trusts to more, complex type strategies. But let's start with basics. What are the things that people that you see that don't have and they don't have it right?
Yeah. I mean, if you want to start with super basic. I mean, and this goes back to the comment of, if I don't have a tax problem, I don't need documents. Forget about, dying and where assets are going and all that kind of stuff. But some of these documents are effective while you're still alive, having to do with management of your assets in the event you suffer a mental incapacity or, control over
physical
medical
incapacity.
decisions.
Yeah.
Interestingly, my son, as I mentioned, he's turning 18 tomorrow.
I was going to say.
And when he turns 18, I'm no longer his legal guardian.
Right.
Should something happen to him, medically, and an accident occurs while he's away at college, in theory, I don't have the right to receive any information from the doctor.
No.
Medical information is privatized, and I'm not a legal guardian. So
you have to go through a guardianship post.
Yeah, and that's a nightmare. Alternatively, what I will have him do tomorrow is sign a healthcare proxy.
You're probably bringing it home tonight.
Yeah, naming me and his mother as his proxy, and therefore the doctors will legally be able to speak to us and take direction from us should something go wrong medically. Again, as people age, this is even a bigger issue, right? If you have an elderly parent and they don't have a power of attorney in place, or they don't have a healthcare proxy in place, and something happens, where they become mentally incapacitated, or they need help managing things, and you don't have documents, they're now not in a position to sign documents once they become mentally incapacitated.
Right.
And therefore we have a big mess on our hands. So,
and we can't, as advisors, like we can't take orders from somebody that does not have a durable power of attorney.
Correct.
Like we can't do it. It's not legally there. Now, I wanted to just stop for a second. As your kid turns 18, those two documents are really, really important. The most frustrating thing I think about sending your kid to college is, even though you're writing the check for school, you don't have access to their grades.
Yeah.
They have to grant you authorization to their grades.
Yeah.
Like, but that's because they're 18.
That's right. Once they're an adult, your rights are gone.
Your rights are gone.
The fact that they're on your health insurance doesn't mean anything. The fact that you're paying the bills doesn't mean anything. They're 18. You're not their guardian. You have no rights.
So tomorrow we got durable power of attorney, advanced healthcare directive. How much time do people really spend discussing what it is that they would want on their advanced healthcare directive? Because let's just spend a little bit of time on like what that really is.
Yeah. So there's really two components to the document. One we've sort of spent the last few minutes talking about, which is authorizing somebody to
make decisions,
receive information, that kind of thing. I'll refer to that as your healthcare proxy. In addition to that, there's what you just brought up as an advanced directive. Sometimes you'll hear the term living will, and essentially that is a statement of how you feel about certain situations. Generally speaking, the big one being kept on life support in the event that the doctors have deemed this pretty hopeless, a vegetative state. The end stages of life. If you ask most people, they don't really want to be dragged out
for years and years and years
in that situation.
The Terry Schiavo case is the thing that always comes to my brain.
Yeah, that we're both dating ourselves here.
Yes,
but yes, that was
how many years ago? Was that 20 years ago?
It was more than that, I want to say.
Is it really?
Yeah.
Oh my God, I am
have
getting
to
old.
Google it, but
Google that, Tony. Terry Schiavo.
Yeah.
SHIVO. Or like perplexity now, right?
Yeah, SCHIAVO, maybe something like that. If you put in Terry and start spelling it, it probably comes up. But yeah, I do think it. You got it?
What year?
Yeah,
get the hell out of here!
My God,
1990. I am really dating myself. I was 1 year in the business.
I was 15.
But based on the Terry Schiavo bullshit that went on. And that was really a battle between her husband and her parents, because neither one of them had authorization.
Right.
And they were arguing, and she was on life support for
years. Wow, that's 8 years.
8 years. 8 years.
Yeah, and right, that's exactly what happened. And I was only 15, and I remember this. Obviously, I wasn't practicing law at the time, but
that's what inspired you to practice law.
Sure.
I'm kidding.
Yeah, but yeah, no, that's the type of stuff that can happen when you don't have a document. And by the way, putting a healthcare proxy and living will or advanced directive together is so easy. It's such an easy, inexpensive thing to do. It's like insane not to do it.
The problem that I hear often from my clients is, I don't really feel comfortable putting so-and-so as my proxy. I feel they're going to pull the plug like immediately.
Right. I get, this is a lot of jokes in the meetings about this kind of thing. You get the, they're going to pull the plug if I stub my toe. I hear that a lot. That kind of.
My dad. This is a funny story. We got the document. My dad's in ICU for 91 days, and he goes into like an LTAC facility, which is like a really high-end ICU facility. And he crashed. He was, we had him in hospice, and like we literally pulled the plug 3 times on him. 3 years later, when he kind of came out of he literally battled out, and he was kind of back. He wasn't back, but he was cognitively back. And he goes, why didn't you just pull the freaking plug on me? And I'm like, I did 3 times. You did? I'm like, yeah, that's what you said to do.
Yeah, right.
And I pulled the plug 3 times on you and you battled back all 3 times. So like you were stronger than the document.
Yeah. Wow.
That was pretty cool.
Yeah. That's a unique situation. But yeah, again, these documents are really easy and so silly not to do them.
And they're inexpensive. I mean, it's, to me, those 2 documents, most people that we meet, the document is not existent and or it's 25 years old.
Right.
And like the person they've named is not even in their life.
Right.
And there's no alternate, there's no backup.
Or is elderly, and they have adult children who they're close with that, of course, would be the people to make these decisions.
Much smarter.
And they haven't, put them in place yet.
Yeah. Now, on a power of attorney, what kind of conflicts of interest could be in a power of attorney? Like naming somebody, is there like somebody that you would prefer to name versus somebody not prefer to name? Like, is there some standard rules in that?
I mean, listen, most people, first off, they're married. Obviously, they pick their spouses
Correct.
as their power of attorney. And if they have adult children, chances are they're picking one or more of the children. What comes up a lot in this area is I have 2 children. I have 3 children. How do I choose? I want to pick all of them. And it's not my favorite thing.
I think now you're just requiring 2 or 3 people to make a decision and sign off on it.
And then they have to get together and agree on something. And not everybody agrees on things. And the phrase "too many cooks in the kitchen" comes up in this context a lot. And most of the time, this idea that they want to pick multiple people comes from a place of, I'm offending the one I didn't, pick. Right. And I don't believe that's a reality.
And I look at it as like, I'm an only child, so like I have a different perspective, but it's like, I just relieved you of the burden of having to make that decision.
Right,
you should be thankful.
Yeah, right. I don't think that's, of course, in certain scenarios, you could have a sensitive kid that's offended.
Happened in my family. My father-in-law, we did a document naming my wife. My wife was the closest person. She lived 1.5 miles from them. People in other states who weren't here got upset. Yeah. And then he changed the document to the 3 of the kids. And I was like, you're just what are you doing?
Yeah. And
you're making this so much more complex than we have to.
Right. And geography is certainly a factor in making a decision.
And my wife's like, just take me off. I don't want to deal with this now. Like just make one person. I don't care. I just was the was a close person.
Here. It's easier for me to do it. But if you guys want to do it from another state, go right ahead. Yeah.
Yeah. I'll just call you on the cell phone.
Yeah.
And tell you what's going on.
Yeah. I have 2 brothers, and both my parents are still alive. And frankly, I can't even remember who they appointed. I should know that since I was involved in doing their documents.
You probably drafted it.
I don't remember, but none of us will be upset. And of course, we'll all talk to each other anyway, regardless of who the person ultimately signing off on the decisions are. So
we got these 2 core documents. Then we talk about, let's go to some other documents that are just standard documents.
Yeah, the other standard documents, you obviously have your will, which would be the most commonly known document to people. And then also potentially revocable trust would be the other.
Let's spend some time on revocable trust, because I think there's a misconception. It's like, if the state doesn't have probate, you don't really need a revocable trust, which means I can take it back, right? Versus an irrevocable trust, where that means once you gift, you really can't take it back without major consequences.
Yeah, a revocable trust, sometimes called a living trust, is generally designed to avoid the probate system. All right, and just to be clear, because this is a huge misconception on what probate is. I hear people say all the time, I need to put my house in a trust so that my house doesn't go through probate, or
correct.
This doesn't go through probate, or that doesn't. Assets don't go through probate. But what probate is the process of getting an executor appointed.
Correct.
So what happens when somebody passes, generally speaking, is an executor is appointed to handle everything that needs handling. The person's
organize the
accounts
assets,
need to be closed out. Their bills need to get paid off.
Close credit cards.
Their tax returns need to be squared away and paid off. Someone's got to make sure the assets go where they're supposed to go. Maybe it's selling the house. Just doing all this finalization stuff is handled by an executor. All right. So let's just use an account as an example. All right. Parent has an account at the bank. Parent dies. All right. The beneficiaries of the parent's estate are the 3 kids. the 3 kids can't go into the bank and just say, dad died, give me the money.
Right.
The bank doesn't talk to the beneficiaries of the will. They deal with an executor. Now, the executor can't go into the bank and say, hey, I'm the executor, give me the money, until they've been officially appointed by the county surrogate as the executor. Okay?
Stamp. Boom.
Yeah.
You are the executor.
Yeah, they
Boom.
basically they're
certification.
the certificate.
That lasts for a certain time frame.
Yeah, and the bank wants the certificate. That's what they care about.
Raise seal.
Yes, raise seal. So if the executor comes into the bank to take the money from the account and do what they need to do, the bank's not talking to them unless they have a certificate. Okay? So the process of getting certified is what probate is. So the executor generally will, they'll go down to the county surrogate's office and they'll show the will and they'll have a conversation with the surrogate and then sign some paperwork. And it looks different in different places. It could look substantially different in different places. Probate in New Jersey doesn't look like probate in Florida or probate in New York.
Right.
But one way or another, this is what probate is. It's the process of getting an executor appointed to represent the estate. Once the executor is appointed, things can get done. Until the executor is appointed, things really can't get done. So what a revocable trust does, now going back to the beginning, is the executor is in charge of handling the assets that belonged to the decedent individually that are not beneficiary designated. Okay, so
life insurance, annuities,
life
IRAs.
insurance that has a beneficiary, annuities have a beneficiary, 401k has a beneficiary. That does not fall under the purview of the executor. Okay, nor do jointly held assets. If husband and wife own an account jointly and husband dies, the wife doesn't need to probate to access the account. The account already belongs to the wife immediately anyway.
Correct.
Okay, so this is about handling the assets of the deceased person that they individually owned and were not subject to beneficiary designations. All right. So let's just say it's somebody's house.
Yep.
Okay, and there's not joint ownership, or there's just there's just a sole owner of the house, and the person dies. As I just went through, the house can't get sold. No one can do anything with the house until an executor is appointed.
Correct.
All right. If the house is owned not by the person that died, but by a trust, and generally we'll say this would be the revocable trust that we're talking about, then it's not an executor that handles the selling of the house or the transfer of the house to the beneficiaries. It's the trustee. So what happens is if the person that owns the house has retitled the house in the name of their revocable trust so that the deed reflects that the trust owns the house, generally speaking, the revocable trust is going to say, while the person is alive, they're the trustee and they're the beneficiary. Okay, so
Right.
You're not giving up any rights to the house. You could still live in your house. You could still sell your house. Nothing changes in reality. Right, just the name on the deed changes from your name to the trust name. But after you pass, the trust document would name a successor trustee. And that successor trustee then has the right to handle the house after you pass. Now, that successor trustee does not need to be certified by the surrogate. They have the immediate right to act on the house. So if, again, your bank account is not owned by you, it's owned by your revocable trust, then instead of having to wait till an executor gets appointed for someone to have access to the account and pay off the funeral costs and the bills and get the money over to the kids, this can happen much more quickly.
It's the fastest process that I've ever seen.
Right, because
it's incredibly fast.
Yeah, there is no need to get certified by that surrogate.
Because technically, if you kind of go backwards for a second, the house would have gone, you would have had the certification of the executor. The house gets sold. The money would go into an estate account. The estate account would then, have to go through a process
Be used to pay off bills and
and then distribute
and that kind of thing.
out. It just prolongs.
Yeah, it prolongs the process. And in certain areas, just the process of getting an executor appointed can be really onerous and potentially really expensive. So revocable trusts, especially in those jurisdictions, are really valuable to avoid that whole process.
And I think it clears up. It just because it technically that thing we were talking about earlier, where if I had the house in a trust, like in a revocable trust, the basis would have been assumed. So you would have a tax problem. But the revocable trust, it all passes through to your personal tax return. So you get to step up.
That's fine. I'm glad you brought this up. So what we talked about before with the step up in basis, and just to recap 10 minutes ago conversation, the step up in basis is very important to the beneficiaries who receive the assets because it prevents them from having to pay tax when they go to sell the asset. Right. So I bought the house for $500,000. I died and it's worth $1 million, and my kid goes to sell it for $1 million after I died. In theory, there's $500,000 of gain to pay taxes on. However, because the basis was stepped up at the client's date of death to the date of death value of $1 million, there no longer is a gain. And just again, to be
could actually be a loss
here,
could actually be a loss.
The formula to determine gain is sales price minus basis. So the higher your basis is, the lower your gain is going to be. There are, I guess, social media posts or videos. I'm not a huge social media person out there. I only know this because it seems like every third client to come into my office says this, that indicate that the step up in basis is only available to you if your assets are owned in a revocable trust. Okay, that's not true. Yeah. The step up in basis is available to you if you own your assets directly or if you own your assets in a revocable trust. A lot of times it's not available to you if you own your assets in an irrevocable trust.
Correct. Which you see, or you gifted it to your kids
or a
outright.
Straight gift to the kids. Now your death doesn't create a step up in basis on an asset because you don't own that asset.
Right. And that could be far greater for many people than any potential inheritance tax that they could be looking at.
A lot of people these days aren't subject to inheritance taxes.
Correct, because you've got what's the exemption right now?
So under the there's a few different things to think about. So under the big beautiful bill, the federal estate tax exemption has been quote unquote permanently increased to $15 million. The reason I put that in quotes is permanent only means it's this way until the next tax law. And how many tax laws have we had since 1990? A ton. I've seen a lot of different estate tax exemptions in my 25 years of practicing law. Interestingly, this one, that I just said is $15 million. When I first started practicing law, this number was $675,000, just to see the big difference between the two numbers.
Huge.
So that's federal estate tax exemption. Okay, then the state of New Jersey has an inheritance tax, but note that the inheritance tax doesn't apply when you're leaving assets to spouses, children, grandchildren, even parents or grandparents.
Is that Class A beneficiary?
Those are known as Class A beneficiaries. So
versus Class C, which would be uncles, nieces, brothers, sisters.
Correct. So you have siblings. So you have a class that involves siblings, sons-in-law, daughters-in-law. They are subject to the inheritance tax at a little bit less of a rate. It's 11% is the starting rate for those individuals.
Above a certain number too, right?
Yeah, and then above $25,000.
Yeah, okay. And then, small number.
And then you have like the nieces and nephews, or the big one that I always tell people, be very careful. Couples that aren't married to each other. In the eyes of the law,
domestic
there's
partners.
no relationship. A domestic partner is different. So
technically, yeah, right.
So a domestic partner is a Class A beneficiary in New Jersey, meaning that there would be no tax going partner to partner. However, people think that because you live with someone, they're your domestic partner. That's not true.
That's the point. Yeah.
A domestic partnership you have to apply for in New Jersey, and you can't apply for it unless both parties are 62 years old.
Oh,
yeah.
Really?
Yeah. 62 years old. Live together, rely on each other there's a whole host of
so somebody that's
rules.
45 cannot be a true domestic partner.
If you're not married to your partner and you can't apply and you didn't apply for domestic partnership, and one person dies and the other person inherits, they are a Class D beneficiary subject to the highest possible New Jersey inheritance tax rate because they're basically an unrelated party.
Which is as we began this conversation with people that have been married 2 or 3 times and are now with a domestic partner, but do not want to get married again.
Yeah.
There's and they're going to pass each other assets. That's difficult.
Yeah. I mean, think about today's day and age, houses are easily in a lot of locations in New Jersey, $1 million, right?
Yeah.
No, that's not anything
Starter homes for
crazy.
800,000 now, right?
So imagine, so-and-so has $1 million home. His part, I'll say he owns the $1 million home. She moves into the home at some point. They've been living together for 15 years in the home, basically as a married couple, never got married. He dies, leaves her the home.
Yep.
She has to pay $150,000 to $160,000 to the state of New Jersey when she receives this home. And by the way, where's she getting the money to pay for this? It'd be one thing if he left her $1 million cash.
Yeah, and $1 million house.
But when you're just leaving the home, now she's got to sell the home just to pay the tax bill
or mortgage it if she can.
Right.
If she can or he can.
It's a huge problem. People don't pay attention to it.
Cluster.
So that's New Jersey inheritance tax. Right?
Now, Pennsylvania and New York each have different.
So Pennsylvania has an inheritance tax
for everybody
except spouses. So Pennsylvania, unlike New Jersey, hits the kids with an inheritance tax when they inherit from their parent. Now, fortunately, the rate there is only 4.5% when it's to a child. So, generally speaking, it sort of is what it is, and people don't go nuts
on a lot of money.
About it,
but on a lot of money, it becomes a lot of money.
Right. And then the state of New York has an estate tax, so kind of similar to the federal estate tax, where it's a tax on the value of the estate, not necessarily where the New Jersey and the Pennsylvania is a tax, on the beneficiary inheriting the money. The federal and New York is a tax on the estate itself. And so under federal law,
including things that went via beneficiary designation.
Yes, correct. So that's another thing. People tend to not understand what's included in the value of their taxable estate. And as well, if the exemption, again, under the big, beautiful bill is $15 million, well, I don't have $15 million. I don't have anything to worry about. Don't forget, you have to factor in the value of your real estate, your retirement accounts, the payouts on life insurance. People say, I thought life insurance is tax-free. Life insurance is income tax-free, meaning the beneficiary does not have to report the proceeds that they received on their 1040 the following year. Okay?
Correct.
However, it's still an asset in the decedent's estate for estate tax calculation purposes. Okay, so sometimes people forget, hey, this is a bit.
I got 20 million. I got 20 million. I'm under the 30. No big deal. Oh, but you got 15 million of insurance that's not in a trust.
Yeah, right. So, So again, people a lot of times underestimate the size of their estate. But yeah, everything counts when calculating the estate tax. And by the way, so New York, as we were saying, has an estate tax, where the federal limit is about to be $15 million. The big, beautiful bill kicks in this number next year, starting in 2026.
Right.
New York's current estate tax exemption is $7.16 million. So
anything over 7.1.
Correct. Is
subject
to the New York estate tax. For rate purposes, there's a sliding scale of rates that tops out at 16% is the highest New York.
It's pretty big
estate tax rate. Yeah, these are substantial.
So
taxes.
New York planning becomes super important.
Yes, for sure. And the other interesting thing is that the federal estate tax has a concept called portability.
Yes.
Which allows spouses to use the other spouse's estate tax exemption. So in other words, if first spouse dies and has a $15 million estate tax exemption that they didn't use, right?
Correct.
And by the way,
let's just pretend for a moment, $30 million death.
Yeah, but for a couple, because of portability, the thought is, okay, really, they can leave $30 million tax-free to their kids, because if the first spouse to die, and I guess we should state maybe what you and I might consider the obvious, but anything that you leave to a spouse is automatically tax-free.
Correct.
Under all these states and federal
Even
laws.
IRAs get rolled over to another IRA and the tax is deferred.
Correct. So
annuities, the tax is deferred.
So if a husband leaves $10 million to his wife, that he doesn't use 10 of the $15 million of estate tax exemption. That's free anyway. He didn't use any estate tax exemption.
Right.
The wife then can port the husband's $15 million estate tax exemption onto her own $15 million estate tax exemption, leaving her with $30 million of estate tax exemption. And that she can pass to the kids up to $30 million tax-free later on when she dies.
And there's a pro and a con to the portability.
Yeah, I mean, portability, first of all, you have to apply for it. You have to elect it.
Upon death.
Upon the first spouse's death. So when the first spouse dies, if the surviving spouse wants to port that person's estate tax exemption, they have to elect to do so on on what's called a Form 706 or an estate tax return. And sometimes people, don't realize that. They fail to do it.
Yeah.
So that's one thing.
That's a really important factor.
Yes. Second thing is portability sometimes is not as good. Relying on portability is sometimes not as good as the first spouse using their $15 million
funding the unified credit, their credit shelter trust, the family trust, whatever you want to call it.
Correct.
But physically getting it out of the estate.
Yeah, and I think so. So I think it's always easier to understand this when you throw numbers out there.
Correct.
Okay. So let's just say that each spouse has $10 million worth of assets, in their name. So the couple's worth a total of $20 million.
Yep.
And the first spouse dies. And the thought is, okay, the surviving spouse is going to inherit the $10 million from the first spouse. That will bring her up to $20 million. But because of portability, her exemption isn't $15 million. She elects and gets it up to $30 million, and therefore we're good to go.
Correct.
Well, what happens if the assets double in between the first spouse's death and the second spouse's death? Now the surviving spouse has $40 million and only $30 million of estate tax exemption, and therefore $10 million will be subject to federal estate taxes. And I don't even know if we've ever said this in all this conversation. Federal estate tax rate is 40%.
Right.
Okay, so that's a $4 million estate tax bill. Now, let's take a different approach. Let's say instead of the husband leaving the wife $10 million, the husband leaves his $10 million to a credit shelter trust, which is essentially a trust for the wife's benefit. Okay?
Formed in the will. Testamentary trust, which means formed in the will.
Correct. So at the husband's death, instead of the $10 million going to the wife, the $10 million goes to a trust for the wife's benefit. And under the terms of the trust, the trustee can make distributions to the wife, and the wife could be the trustee, so that she doesn't lose out on the money. But instead of being owned in her name, it's owned in the trust name. Okay? So now the dust has settled. There's $10 million in the trust. There's $10 million in the wife's name. And instead of being able to port $15 million of exemption, the wife can now port $5 million of exemption because the husband has used $10 million of exemption in funding this trust. Remember, assets that go to a spouse, automatic tax-free, don't require the use of exemption. Assets that go to this credit shelter trust for the benefit of the spouse does require the use of exemption. And therefore, the wife now, between the amount she has, her own $15 million exemption, and the $5 million that she ported, she has $20 million of exemption. Okay? Same results play out, the assets double.
Yep.
Well, when the assets double, the wife doesn't have 40, the wife has 20, and the trust has 20.
Correct.
When the wife dies, the $20 million in the trust isn't part of her estate for tax purposes. Those dollars go to the kids tax-free.
Correct.
The $20 million in the wife's name is in her estate, but she has a $20 million exemption to cover that.
No estate
and therefore
tax.
No estate tax. So in this example,
yeah,
we got rid of $4 million in estate tax by not solely relying on portability, but instead funding a trust for the benefit of the wife. So funding a credit shelter trust at the first death, instead of simply leaving everything to the surviving spouse, could be a significant benefit at the end of the day.
creditor proofing.
And creditor proofing.
Like
right.
there's significant, but like, so one of the things that you're thinking about there is that, okay, when we have the growth in the credit shelter trust, that 10 going to 20 won't get a step up in basis.
That won't get a step in basis. So,
but like to me, I might be holding on to stuff anyway, right? But it's if I liquidate, it's a $2 million tax as opposed to $4 million.
Correct.
It's still a $2 million spread.
It's still a win. Yep,
right?
Absolutely.
Now, the portability, what if 10 years from now, the exemption amount drops from 15 million back down to 6 million?
Yeah.
What am I kind of lost the portability because it's now going to be the 6 million.
No, you still port at you still keep the amount you ported. So
at the date of death.
At the date of death.
But the spouse would only have her 6
exemption
million.
Will drop. That's correct.
Okay.
And by the way, what I keep meaning to say, which is extremely important, is the state of New York doesn't have portability. Okay. So for people living in the state of New York, funding these trusts
is incredibly
important because otherwise you throw away the first spouse's $7 million estate tax exemption, which, if the couple is worth a total of $2 million all in real estate, insurance, big deal. But a couple that has, a home in New York,
Florida
a bunch
house,
of life insurance and retirement accounts that easily exceed $7 million, you're creating a taxable estate by just leaving assets to your spouse instead of leaving assets to a trust for the benefit of your spouse.
Yeah, that's interesting. So we started off, we were walking with durable power of attorney, advanced healthcare directive. We now went into fast lane with the revocable trust, but more importantly, this credit shelter trust, which I think is, we've been talking about this for personally 35 years, and that nuance between the different states. In the state that you're in, if you're in another state, you could have a different estate tax because there's a bunch of states with different estate taxes, right? Now, go back to a conversation earlier about because of the inheritance tax in New York, there is no technically probate tax, but like Florida has a probate tax.
Florida's probate, and I don't practice law there, so I hope I'm not misstating anything.
Conceptual, this is concept.
I believe that their probate fees are based on the size of the estate.
Included in whatever's not in the revocable trust, the living trust.
Correct. Assets in the revocable trust. Yeah, in the probatable estate, we'll say.
Which is a pretty big percentage.
Yeah, that's right. So for Florida residents, my parents moved to Florida a number of years ago.
So did mine.
And first thing I did, you gotta
have the living trust. Gotta have it.
Yeah.
Gotta have it. It's just but the house, you technically don't, because in Florida there's homesteading and there's other things, right?
Yep.
But we're not talking about Florida. But it's so I've got this, but now, if you've got this $20 million or $40 million estate, I think there's a big mistake that a lot of people make, which is when it passes from one gen to the next generation, it's how is it passing? Meaning, is it staying in trust or is it the mandatory distributions?
So we're talking about the use of trust for non-tax purposes.
Correct.
Okay. So far we've talked about why trusts help with estate taxes and stuff like that. All right. So there's the issue that you just raised, which I'll address first. And then there's also the issue of, we just talked about why you leave assets to a trust for your spouse for tax purposes.
Creditor
creditor protection. There may be
if they get remarried, that helps protect it,
right?
Which you want them to be.
Right. What if I leave assets to my spouse, and then he or she remarries, and now instead of the kids ultimately getting the money when my spouse later on dies, their new spouse gets the money when they later on die.
Or they get a divorce and they had all this money sitting in their brokerage account and they lose it because of alimony or palimony.
Yeah, right. Or and what about kids from different marriages, right? So it's couples that have kids from different marriages, right? I have 2 kids. My wife has 2 kids. I die. I leave my wife all the money. My wife dies. She leaves her 2 kids all the money.
You know how often that happens?
What happened to my kids?
You know how often that happens? Way too often.
So there are special types of trusts that you can use for your spouse The big one being called the QTIP trust. That
qualified terminal interest property trust.
Yes, which is the acronym is not important for people to know, but yeah, the concept is that it's basically designed to allow you to leave assets in an unlimited amount tax wise. So earlier I had
100 million.
Right. Earlier I had said leaving money to your spouse is tax free, but leaving money to this trust for your spouse isn't tax free. You have to use up your exemption. Okay. Well, a QTIP trust is an exception to the rule. Leaving money to a QTIP trust is tax-free, estate tax-free. But what it does is it allows you to determine where the money goes when the spouse dies. Right. So now, if let's take the example. I'm married with 2 kids. I have 2 kids. My wife has 2 kids from her first marriage. I die. I leave my money to a QTIP trust for my wife's benefit. This trust pays her an income stream. Whether it's on a monthly basis or a quarterly basis, you can play with that. But, so I'm not like leaving my wife out in the cold, like I died and I took all the money away.
Right.
My money's still being used to support her during her lifetime. But when she dies, even if her will says I give everything only to my 2 kids, her will doesn't affect the terms of the trust. What the trust says is when she dies, it goes back to my kids. Yeah. So it allows me, after I die, to still maintain sort of control over the ultimate distribution of where this money's going.
Which I think when you flip the switch on that, it's also really good for the surviving spouse to basically say, they get married and then money becomes an awkward thing during this relationship. And it's like, well, the trustee.
Yeah, it's an excuse.
It's locked up. I can't get it. I'm sorry, honey. I love you, but I can't give you $10 million.
That's all I have.
I can't invest in your shitty business.
Right, exactly. So yeah, that's right. It's almost like a built-in prenup.
It's a built-in prenup without having to get a prenup. Yeah. Even the credit shelter trust serves the same way unless the spouse is her own trustee, because then there's really no...
Yeah,
and that's why I like the co-trustee, somebody.
We could always, a lot of times I'll build in provisions where if you want to make the spouse the sole trustee, allowing them to sort of control how the money's invested. In other words, if the house goes in the trust and they want to sell the house, they don't have to get somebody else's permission to sell the house.
The kid to sell, the trust who's emotionally connected to the house where they shouldn't be.
Yeah, but to take distributions from the trust requires the approval of an independent trustee.
Yeah,
kind of thing.
So, smart decisions here.
Yeah. So, and then what you had asked about when I sort of derailed this conversation into talking about trust for spouses was, trust for kids.
Yeah.
And I am such a big proponent of this. I talk to pretty much all of my clients about it. The general way that people plan, if you're doing your docs online, if you're doing your docs with an attorney that maybe doesn't focus his whole career on estate planning.
Yeah, specializes in something else.
Right.
Nice guy, but specializes in something else. Danger.
Yeah. They understand that we shouldn't give money, to a 10-year-old. Right.
Right. Can't technically give it to him anyway.
Right. So
court won't allow it.
Let's use my kid as an example. We shouldn't give money to an 18-year-old. We'll say that, right? Because you can give money to an 18-year-old, but we shouldn't. Right. And most people understand that.
Yeah.
Right. Like if you die and let's just say, let's take a life insurance policy, a $2 million life insurance policy, and now your 18-year-old gets a check for $2 million because they've been named the beneficiary of the policy. That's going to not end well.
It's going to be a hell of a bender.
Right. So I think most people understand that in this event, that instead of the money going to the kid, if they're below a certain age, the money should go into a trust for the benefit of the kid until the kid's older and you appoint a trustee. So, example, in my world, if something happens to me and assets go to my 2 kids, they each have trusts that will receive the money, and my brother is the trustee of the trust. So my 18-year-old gets this, $2 million, or the 2 of them get $1 million a piece or whatever it is. The first thing they're doing is they're buying Ferraris, right?
Yeah.
But because the money is in the trust, they're not allowed to do that unless my brother says that's okay, which I know he's not going to do. Right now, my brother might say, "Hey, I get that you need a car. Let's use $30,000 from your trust, to purchase a car." So, this idea of what we have trusts when the kids are younger. I think a lot of people do plan that way and understand that concept. And a lot of times you'll see things like when the kid turns 25, the trustee has to turn over a third of the money to the child. And when they turn 30, they turn over another tranche of money to the child. So this gets the child used to handling money. But by the end of the day, by the time the kid is 30 or 35 or whatever age you ended this thing, the kid has all the money out of the trust and the trust is no longer. Okay. I don't love that. Keeping the trust in place for their entire lifetime has some pretty significant benefits. Okay. Yeah. One of those benefits, the kid not being able to manage their money on their own. Yeah. That ultimately, hopefully goes away.
Right.
Right. So, by 35 years old, hopefully that you're 30, whatever you deem appropriate, the hope is the kid can handle this. But by keeping the money in the trust instead of turning it over to the child, you get asset protection for the child, right? So let's say the child is getting sued or going through a divorce or
business creditor,
just has creditor problems. So whatever it is, someone's coming after that child's money.
Right.
The money that's in the trust is not deemed that child's money. Yes, the money can be used for the benefit of the child for whatever reason, but it's not the child's money.
Right.
It's the trust.
Unless there's a mandatory distribution at a specific age.
Correct. Right. If you mandate that the child gets a third at 25, well, now a third is the child's money.
Right.
But as long as we keep it in the trust, it's not the child's money. So the only time I like to see money exit a trust is for an expenditure. Right. So if the money is going to be used to pay for college and then the child gets sued the next day, the creditor can't say, yeah, that money that came out of the trust that went to the college give me that money back.
Yeah, can't do
it's
it.
Gone.
Yeah.
So I don't want to see money exiting the trust unless it's for an expenditure. And I mean an expenditure. I don't mean an investment.
Right.
If the thought is, hey, the kid wants to invest and buy Apple stock, let's take money out of the trust so the kid could buy Apple stock. No.
It's buying the trust.
The trust can buy Apple stock.
We want to buy a collector Ferrari that has never been driven. You're never going to drive it.
The trust can buy that.
The trust buys
Yeah,
it.
that's right. So we want to buy assets, capital assets in the trust. A home. The trust can buy a home. The trust could buy a business. The trust could buy anything.
That's a huge misconception. It's like, well, I don't have control over the money. Well, it can buy all the things that you want it to do.
Yeah.
Like it can, even if the trust owns the house, the trust can pay all the expenses.
That's right.
On the house.
Yeah. So
to maintain the house.
So there's that advantage, the asset protection, which is huge. And trusts have remainder beneficiaries. Okay. The remainder beneficiaries dictate where the money goes at the death of a primary beneficiary. So let's just say I fast forward my son's life 20 years and now he's married with kids.
Yeah.
All right. I die, I leave him money. Let's say I didn't leave it in a trust because I determined he's old enough, he could just have the money.
Yeah, he's smart.
Right. So now he's got the money directly. Later on, he dies. When he dies, she gets the money.
Yeah.
So now money's gone from me to him to her. And I really hope her to my kids or my grandkids, his kids.
Correct.
But I don't know that. She could remarry. She could spend all the money.
She could spend it.
I don't know. If the money's held in trust for my son instead of in my son's name, then when he dies later on, while his personal money might go to his wife, the trust money will go to the remainder beneficiaries of the trust. Well, guess who the remainder beneficiaries of my son's trust are? It's his future children. And by the way, if he doesn't have children, it's his brother.
Correct.
So this way I know I'm leaving money for my kids and it's there if they need it. But if they die before that money's all gone, I'm saying where it goes.
All estate tax free too.
Yes. All estate
because it
tax
never
free.
was included in their estate for
Correct.
estate tax purposes.
Correct.
Yeah. On the second death. That's dynastic planning. That's powerful planning. That's something that people are like, oh, it's complex. And I'm like, well, think of it as like in investing, you have registrations. You have an individual account. You have a joint account. You have an IRA account. You have, maybe an LLC account. You have these different entities. It's just a registration. So now I have, the John L. Smallwood, blah, blah, blah trust. Yeah. And I have a co-trustee and it's a registration.
Yeah. People always say, what do you mean a trust? Like what is the money just?
It's complex.
Does the money just stay in cash? Like what is a trust?
The bank is taking all my money.
It's just a title on an account.
You can buy whatever you want in a trust.
You leave your kid $1 million and they want to invest that money in a brokerage account ABC investment firm, they're going to open up an account at ABC investment firm and put it in there, and then that's going to be invested in stocks, bonds, mutual funds, etc.
Yeah.
If the money, the $1 million, goes to a trust for the benefit of that kid, the trustee can open up that same exact account at the same exact firm. Instead of being in the child's name, it's in the trust name. Instead of under the child's social security number, it's under the trust tax ID number, and it buys all the same investments. It doesn't change anything.
And you could have, you could do the concept of non-grantor versus grantor. So you can have the trust, in essence, defective and pay tax to the individual.
Correct. That's an income tax concept.
Right. But there's so many nuances.
Yeah, there's tons of different ways to skin the cat.
And the thing that I always keep coming back to is if you're really intentional and smart about your estate plan, you actually get to design exactly what you want to have happen and the contingencies upon death, right? I've seen so many mistakes where, family is gone. The whole family's gone. And the wife's will says, oh, give it, if my kids aren't here and my husband's not here, give it to my 2 brothers. But the husband had 5 siblings also. Right. So you just inherited the 5. Yeah. That's not, that happened.
This is big when there was no kids, right? So and I have plenty of clients where I meet with the couple and they don't have kids. And I say, what do you want to do at the second death? And the one says, well, I want my assets to go to exactly what you're saying. I want my assets to go to my siblings, and he wants his assets to go to his siblings. So put it in my will, but we want everything to go to each other, of course, if one of us goes. So you put in my will that if he's not around, it goes to my siblings, and you put in his will, if she's not around, it goes to his siblings.
Yeah.
Well, guess what? The odds of a simultaneous death are slim to none. Okay, that people
happens.
Love bringing it up, but
happens.
But it doesn't happen a lot. So what's going to happen is one spouse is going to die first.
It's going to be a spread.
Then that spouse's money is going to go to the surviving spouse. So let's kill. I always kill off husbands first. So let's try to be less sexist. Let's kill off the wife first. Okay, wife dies first. All her assets go to husband. Husband's will says, when I die, if my wife's not around, my siblings. So now all the wife's money that she wanted to have go to her siblings, because of the order that the 2 deaths occurred, now end up going to his siblings.
Right.
And look, there's ways to solve this problem. It's called planning. So
design.
Yeah, design.
It's estate design.
Exactly.
It really is estate design. It's not even planning, because it's you get to design the outcome of how you want your money to be transferred and who you want it to go to. And it's this is our money that we've created together. It's natural that you would want it to go to your sibling. You might want to exclude your brother. You might, there's things that are coming up, but if you don't design it, it's going where you don't want to. And I want to jump into some of the advanced planning. We started, we started here with inheritance. We started with the basics of the durable power of attorney. But there's some really cool things. So many people are sitting on highly appreciated property where when you look at the sale of it, beyond 1031 exchanges and, opportunity zones and things like that, and charitable remainder trust, those are all different things. Yeah. But it's I want to maintain liquidity of my assets, but I don't want to get robbed in the form of taxation. What are some of the things that we could be doing?
So look, the one I use the most nowadays is a concept called a SLAT, which stands for Spousal Lifetime Access Trust. All right. So
one of my favorite docs.
So to take a step back here. All right. We've talked about that each spouse has a $15 million estate tax exemption.
Correct.
Right? And what a SLAT does is it's where let's call it one spouse uses some of their estate tax exemption while they're alive in the form of making a gift to a family trust.
Yeah.
Okay. So
$15 million bucks.
Yeah. What we haven't really talked about is gifting. There's a misconception out there.
Really? There's misconceptions out there? There's wrong information? Holy shit.
The most you're allowed to gift to someone in a given year is $19,000. Okay. that
Big misconception.
Yeah, and sometimes people say 10,000 because that's what it was a long time ago, and people
when
still have
the
that in
exemption
their
was
head.
675.
Yeah, so this is known as the annual exclusion, and the annual exclusion at one point was 10,000, and it's gone up in $1,000 increments over the last however many years, and now it currently sits at 19,000. And people say, well, I'm not allowed to give anybody more than $19,000 in a given year without paying tax. Okay,
Correct.
That's not true. All right, so you are allowed to give during your life without paying tax up to $15 million on, under this new estate law. What happens is you just use your exemption while you're alive. In other words, if I made a $10 million gift, whether it's directly to somebody or to a family trust or whatever, I don't pay taxes on that. It just means that when I die, instead of having $15 million of exemption left, I only have $5 million of estate tax exemption. I used $10 million of it while I was alive.
Right.
Just as an aside, what the $19,000 represents is how much you could give away to each individual person each year without dipping into your $15 million estate tax exemption.
Right.
So if you give, your two kids $19,000 each this year, it doesn't count. You don't have to reduce your $15 million at death.
Correct.
Okay. If you give $10 million worth of gifts, you don't pay taxes on it. You're just reducing.
But now, if you're 45 years old or 50 years old and you gift to a spousal lifetime access trust, potentially that money, grows and grows and grows without the inheritance tax.
So look, in theory, some people, just to get this concept across, someone might say, okay, I gift assets so that my estate is reduced. If I die with less assets, that means there's less likelihood
less
of
potential
taxation,
estate tax.
So in other words, if I have $20 million,
right,
and I die, and 15 of it's exempt, that means 5 million subject to tax. So I'm going to give away $10 million so that I go from 20 down to 10. And therefore I'm below the 15. But you just told me that if I do that, I don't get $15 million, I get $5 million. And if I have 10 and only 5 is exempt, isn't 20 minus 15 the same answer as 10 minus 5? And the answer is, yeah, that's true.
Math is the same.
Yeah. So in theory, you might say, I'm still being taxed on $5 million, whether I gave my money away while I was alive or not. But where you were going with this,
you
were going with this is that, that's assuming you die the second you make the gift.
Which would be brought back anyway because it wouldn't be a 3-year look back, right?
So let's say.
So get going.
You give away the 10 or 15. Let's say you give away the $15 million now. Okay.
Right.
So you don't have any exemption left, at your death.
Except for above the 15. Anything that goes above the 15, you would have a little bit.
So
in the future,
yes. Sorry. You're saying the exemption increases,
assuming it grows for a minute.
There's an inflation adjustment built into the exemption. So yes, it does increase slightly every year. But essentially, you've burned your $15 million exemption, but you've removed the $15 million into this family trust.
Exactly.
Now, what happens is the $15 million grows over time.
Yeah.
So let's say the $15 million doubles between now and the time you die. Well, if it doubles inside of the trust, that's now $30 million that's going to be in the trust at your death, meaning all that $30 million is not subject to the estate tax.
Yeah.
If you held on to your $15 million and it doubles and you have $30 million, 15 is exempt, but the other 15 is taxable.
Subject to estate tax.
That's not the same thing as having $30 million in the trust and having $30 million on tax.
And then if you really get really strategic within this, like if you say, I've got the 15 million, I don't necessarily need the income that it's producing because I have other assets. Now I take that income and I leverage it using life insurance. So I can take a 15 million and turn it into 30, 40 million dollars inheritance tax free without coming out of my pocket.
Exactly.
Without making an annual gift.
So now the trust has $15 million and it's invested in things and it's receiving dividends and interest or rental income if it's in properties or whatever it is.
Yeah.
And now the trust turns around, uses its income to buy an insurance policy. So the trust is buying an insurance policy on the client's life.
Yeah.
And when the client dies, that $10 million insurance policy that pays to the trust. Now the trust gets $10 million. That's also not part of the client's estate. So earlier I said
income
life
and estate
insurance
tax free
is part of the client's taxable estate, not if it's owned by a trust. And I'll even give you better examples of how creative you could be. So and these are real life things.
We're going to get better. I like this.
So I have a client, and he is a 30% owner in a pretty successful business that's growing. And the thought one day is that they would like to sell this business. And the numbers they're talking about in the future, they have to still grow it to a certain EBITDA, but
it's going to it's going to go from a $10 million business to a $100 million business.
They want to sell the business. The hope is, that they're going to one day sell the business for $200 million. Okay?
Right.
This guy's a 30% owner.
Right.
Okay. So in this deal, he's going to hopefully get $60 million. Okay?
Beautiful.
So if he ends up with $60 million, and then obviously when he gets the $60 million, he's a guy, I think he's in his 40s. He's going to invest this money, and that $60 million is going to grow. And again, let's just assume it doubles. That's probably being, way too conservative. It's going to more than double. But let's just assume that it doubles. Yeah. All right, this guy's going to die with $120 million, $15 million of which will be exempt, and the other $105 million will be subject to tax at 40%.
Which is like what, $42 million? Could be some New York, right? Could be a little PA there, right?
So let's call it $42 million of federal tax.
$42 million of inheritance tax for something that you have built over your entire lifetime.
Yep. Okay. So now
is it really fair to take the $42 million? Some people would think it is. You should lose it all. But my position is smart tax planning. How do we avoid the 42 million?
Okay, so ready for this? All right, guy's got a 30% interest in this company. One day, the thought is this thing's growing. They're getting it there. It will be sold for $200 million, but it's not selling for $200 million this second. They're not ready yet.
It's not worth anywhere near that right now.
And what it's worth without an offer to buy is hard to say, right? Everyone knows it's worth what someone is willing to pay for it, but we don't know what someone's willing to pay for it at this point because it's not on the market.
Right. And it hasn't met all the metrics. They're not ready to sell it. It's probably worth a fraction of that.
Okay, so how do we know? Well, we get it appraised.
Yeah, we get a business valuation.
And appraising is not an exact science. You could talk to 20 different appraisers that use 20 different methods that will come up with 20 different numbers.
Right.
We said to the appraiser, look, I know there's a range of how the formulas you use will get you a number from here to here. We'd like the appraisal to reflect a lower value on the lower side of the spectrum here that's justifiable. We're not asking you to be fraudulent at all, but just what's the lowest number we can justify here? Okay?
Right.
So let's say he says though that's that number is $100 million. Okay, so now the client's got $30 million of value. Okay, so but
30% though.
But 30%. So what's the value of this guy's 30%? Now the knee-jerk answer might be, well, if the company's worth 100 and he owns 30%, then the value of his 30% is $30 million.
Right.
Yeah, but that's not true because we're not asking what's the value of the company multiplied by his percentage of ownership. We're specifically asking how much can he sell his 30% for? Forget about the rest of the people aren't selling. He wants to sell his 30% to somebody right now.
Right.
Well, is there a market for that? Does someone really want to come in and buy this guy's 30% interest for $30 million when they don't have any say in how the company's run, when distributions are going to be made, when the company's if someone had $30 million to spend on something, they're going to spend it on something worth $30 million that they have control over.
Correct.
Okay. So in order to get this guy to get someone to buy this guy's specific 30% interest, we have to discount that substantially. So now the interest is down to $20 million.
Two discounts known as.
Yeah. So it's a lack of marketability discount and a lack of control discount.
Yeah, or minority share discount, whatever you want to call it.
So now this guy's, in theory, one day $60 million value, we've knocked down to $20 million.
Or lower, potentially.
Yeah, lower. Now, let's just say for sake of the example, we were able to get it low enough where we knocked it down to $15 million. Okay?
Half of what it's worth.
Yeah. Now, he gifts his 30% interest to this family trust known as a SLAT. Okay. He uses up his entire $15 million estate tax exemption.
Yeah.
Things play out the way we expect. The company one day sells for $60 million. He doesn't get the $60 million. His trust that owns his 30% gets the $60 million. And then the trust gets the $60 million. And as he would have done, the trust invests the $60 million, throughout the rest of his lifetime. And similar to his returns, the trust was able to double the money in the course of his lifetime to $120 million. We saw in the first example, he had the $120 million, 15 was exempt, and 105 was subject to tax, $42 million federal estate tax. Now the trust has the $120 million. He has no exemption left. Who cares? He has no assets. And the $120 million that was going to be subject to $42 million in estate taxes is now subject to $0.
Buy a lot of Ferraris for the $42 million.
So by using
Okay.
business, discounts and business valuations and transferring things before they pop and that kind of stuff.
And you could play like the SLAT could actually, we can get a little bit interesting with some of the, like, where is that trust?
Yeah. So now the question is, okay, so the trust has my $60 million, $120 million. How does that help me? Right. How do I use the money in the SLAT? So generally speaking, SLATs are for the benefit of the spouse. That's the S part of the SLAT, spousal lifetime access trust. And the lifetime access means the spouse has lifetime access to the money. So during the spouse's lifetime, they can access the money in the trust. So the thought is, okay, if one spouse, again, let's call it husband, put these assets into the trust, wife is the beneficiary of the trust, and they want to go now on a vacation and they want to, use some of this money that they've earned. The trust distributes that money to the wife, and the wife, pays for the vacation.
Right.
So the husband,
trust buys the house. Trust buys all the other stuff.
Yep. So now the husband can use the money via the wife.
Right.
Right. And normally that's great. That's fine. That works well, and we don't need to worry about anything. What the pushback generally is from the husband's side is, what if we get divorced? What if she dies?
Yeah.
Right. So in certain states, not all states are built the same as far as their trust laws, right? So similar to how like Delaware, became this corporate haven because they made the laws better for corporations. Certain states have made really beneficial trust laws. All right. And there's a handful of states that allow for what we call self-settled trusts, meaning trusts where the person funding the trust can also benefit from the trust. All right. Right. Again, normally, like
such a valuable thing.
Husband funds the trust, wife benefits from the trust, but the husband isn't the beneficiary. But in certain states, the funder of the trust can be also a beneficiary of the trust and still receive asset protection,
estate protection.
Yeah, from the trust assets. So if we do these trusts in a self-settled trust state, okay, and there's a number of them. The big players in the game these days would be Wyoming, South Dakota, Nevada. It used to be Alaska back in the day, and they're still a safe self-settled trust state. Delaware's a self-settled trust state. There's a number of them. I would think that generally people view the big three as Wyoming, South Dakota, and Nevada.
That's why you see a lot of Wyoming plates in New Jersey.
Yeah, you don't actually have to move to these states to take advantage of their trust laws, although that is one way to take advantage of their trust laws. But having a trustee, one of the located in the state, could allow you to take advantage of the trust laws. Now, I personally have really great relationships in the state of Nevada, both in terms of attorneys who specialize in this tactic and in terms of trust companies that we would hire to act as trustee on the trust. So, when clients come to see me about doing something like this, we'll generally, look at Nevada.
Could there be some income tax issues there too?
Yeah. So
benefits, not issues.
Yeah, benefits. So another nice thing about Nevada is that they're a 0% income tax state.
I have my asset in a Nevada trust and I sell it, but I live in one of the high tax states, such as the state my asset's sitting in right now, which is New Jersey. That's an 11 to 12% tax.
That's right. Now, there are different types of trusts, and you alluded to this
Yeah.
earlier.
And I'm not an attorney, but I just want to make that very clear.
Trusts, there's grantor trusts and there's non-grantor trusts. Okay. In a grantor trust, all income tax attributes fall back to the grantor. So
Correct.
if the trust earned $20 million on a sale and it's a grantor trust and the grantor lives in New Jersey,
It shows up in your tax
it
return.
shows up on your tax return in New Jersey. If it's a non-grantor trust, where the trust is its own taxpayer,
Correct.
and it's selling assets or earning income, and let's say it's a Nevada trust, the state income tax return of the trust would be Nevada, who doesn't have a state income tax, and you can, obtain some substantial state income tax benefits from using Nevada trusts. Now,
On that 60 million exemption, it could be a pretty big number.
yeah, exactly. So
Compounded with the 42 million of inheritance tax, compounded with this, these numbers become
in
pretty
order
powerful.
to get a trust to be a non-grantor trust versus being a grant, different powers are included. So we have to.
There's a level of complexity.
Yeah, we always have to view if we take these powers out of the trust, so that we can get the benefit of the state income tax. What are those powers we're losing, and do I want to lose those powers?
Pro and a con.
Yeah, so we always have to view the thing in its entirety. But yes, there's state income tax games to play with these trusts as well.
Right. And there's nuances, which this is not the space to do that. But my goal, right, in this conversation was to basically take people's brains and open up the possibility, right? The possibility of estate tax for somebody that's got $1 million estate, and estate planning, not estate design,
Yeah.
to the multi-100 million, to the $1 billion. There's so many people that if you don't do strategic planning now, you're losing opportunities.
Yeah,
you're paying way more tax.
Yeah, the example that I just gave,
It's huge.
if we do this now, we could get this guy's whole 30% into the trust.
Yeah.
If we wait 3 years until the business is sold,
You can't do it.
yeah, I can't pretend
you
that $60
can,
million of cash is worth $15 million.
but you've left potentially millions and millions of dollars
absolutely.
on the table that doesn't go to your family. It doesn't go to your ex-wife. It doesn't go to your spouse. It goes to people that aren't going to benefit and enjoy from it. And this is what I want people to understand. It's your money. I think I wrote a book. It's called It's Your Wealth, Keep It, right? This is an essence of keeping your money.
Yeah.
Right. And the generational wealth that you can create through proper estate design might be one of the most important parts of any estate.
Absolutely.
And how you protect it.
Yep.
I mean, this was a wonderfully colorful discussion without charts, without pictures, that tells a beautiful story.
Yep.
What I would urge people to do is, if this has any interest, you should be either directly connecting with Mike. What's your law office has a beautiful phone number. What is that phone number?
The phone number of my office is 732-354-1951.
And what's your website?
My website is Canarick-law.com. I'll spell my last name. It's
spell it.
It's C like cat, A-N like Nancy, A-R-I-C-K, dash like the hyphen sign, law.com. That's my website.
We'll put it in the show notes also. But my urge, right, is if you have money, you should have counsel. You should be talking whether to somebody like me, who's a wealth advisor that's going to help you design not just the estate side, but the big picture of how the money's going to, generate. But the team is what you need to have. And most people don't have a team.
Yep.
And I really value the thinking of strategic planning, right? Because strategic planning does more than just estate tax benefit. It is asset protection. It is understanding how wealth from generation to generation. It's like when you look back at, family wealth, dynastic wealth, one of the largest privately held firms, I believe, is, Cargill, right?
Yep.
I don't see them. They're worth billions. There's no estate tax being paid.
Right.
Because it's tied up in these beautiful trusts.
Yeah.
The Kennedys, the DuPonts, the Rockefellers use this type of planning. And the reason they have the wealth is because they did the planning.
Yeah, they let taxes erode the wealth over the generations.
Right. I mean, if you think about $100 million goes to 60 million, 60 million goes to 30 million.
40% tax multiple times will quickly get rid of the
Yeah,
money.
and then you got to spend and you got to enjoy. And that's why, like the money's gone. So anything you want to say before we wrap up here? Because this was fantastic conversation.
Yeah,
and
this
if
was
you,
great. I appreciate you having me on.
I want to make sure that there's so much value in this podcast. If you need to listen to the entire thing and you need to, there's so many nuances that are going to apply to you. Right. But like, I really appreciate having you on.
Yeah. I appreciate you having me on. And yeah, and everybody's situation is different. And if you go on my website, you can schedule a meeting with me. There's no charge. It's a free consultation. I'll go through the specifics of your personal situation and we'll talk out recommendations and what I think. And yeah, all you have to do, go on the website, schedule a free consultation. That we can do that on Zoom. We can do that in my office, whatever you prefer. But yeah, I certainly encourage people to do that. Getting on my calendar is a little difficult, but if you go a few weeks out, a month out, you should have some openings there.
And I think it's worth like the waiting. Like I always find like people like they've got to get in and get it right now, right?
Yeah, it's funny because these people are 50 years old and they've gone 50 years without doing it, and now they need it done this week. But generally speaking, that's probably you probably don't need it done this week. Get on my calendar, put it on for September, put it on for October. We'll have the appointment, and this way it's there, and we'll meet when it comes, and we'll get it done.
And it's the same thing here. Like people, like I got to meet with somebody on Tuesday. Well, the problem's been here for 25,
Right.
30 years. Like let's not rush. Let's spend the time in the design because right now we have some time, right? But let's get this stuff done right. Let's figure out what is the most important thing to hit first. Because it might be like, hey, I'm bleeding, over here. I got a little cut on my knee. I got to get this fixed, but like my arm is off.
Yeah.
Like I got to fix that first. Like the knee's not the problem, right? But I'm focused on the knee, right? So I urge you, do not get complacent in your planning, right? That's what I'm going to say here. Do not get complacent because being complacent, you will get rolled over and you will lose potentially hundreds of thousands, if not millions of dollars.
Yep.
Thank you.
All right. Thank you.
This is awesome.
Yeah, great.